I thank you all for coming. I'm Jay Pace, editor of the Herald Progress, and this is the first in what I hope will be a number of cooperative efforts with the Friends of the Library, especially focusing on something that's extremely important to me in my job, and that's the First Amendment. I think it's particularly significant that we mark this First Amendment Forum on James Madison's birthday. James Madison, born in King George County and largely considered as the father of the Constitution. And it's also, as I reminded our County Attorney Sterling Reeves a little bit earlier today, National Freedom of Information Day, which we're sure that government officials all over the country have celebrated. And
I've been partying all day.
In any case, what we have tried to do tonight is to put together a group of people in leadership positions and serving other roles in our community who can help us understand a little bit about what our expectations of the First Amendment are in our community. We haven't had a good First Amendment fight in Hanover in years. And not that the Herald Progress is here tonight picking any fights, but there are a number of issues that are in the National Forum today that at one time or another, local leaders and local people need to respond to. And so what we have done tonight is to set up a rather august and distinguished group of folks who serve in various roles in our community. And Louise Seals, the managing editor of the Times-Dispatch, who is our moderator this evening, is going to lead them through a variety of scenarios, of hypothetical situations that could occur in any community. These hypotheticals are based on actual experiences that other communities have had with First Amendment issues. And a reminder, the First Amendment is not merely a press freedom, it's a lot of other freedoms as well, and it is quoted on the inside of your little leaflet if you want to read that, and we'll probably touch on all of those. We want the dialogue to occur between these people up here. This is not going to be a debate in any sort of sense, and we're not going to take questions from the floor, although certainly at the end, if something has kind of piqued your interest or hit a nerve or something, I'm sure that, as a matter of fact, you can block the doors. Now, notice that strategically you can block the doors and ask some of our panelists. But I would ask now that you welcome Dr. Howard Davis, who's a political science professor at Randolph-Macon and has the marvelous distinction of teaching me everything I know about constitutional law when I was an undergraduate. And that was 30-some years ago. I don't know whether constitutional law has changed a great deal in that time, but probably a little bit. Condi Hopkins, who is a businesswoman in the county and a former teacher in the county, and Condi is serving the role, a very important role tonight, as the citizen advocate. As I've grown to know Condi over the years, I have known her to be a person who is not afraid to make a point and not afraid to state her opinion, and also a person, because she taught government for so many years, who has a very deep and profound appreciation for the Bill of Rights and the First Amendment. Sterling Reeves, our county attorney. Many First Amendment issues obviously will involve the chief legal officer for the municipality, and that's the reason that my good friend Sterling is here. Robert Thompson is the designated clergy person. Last time I saw Robert, he was in a lavender dress, but I assume he preached on Sunday morning. I assume he did. But it's good to have Robert here because obviously freedom of religion and religion is involved in a number of First Amendment things that come up in communities. Tom Harris from our staff of the Herald Progress is a veteran community journalist and obviously utilizes the First Amendment all the time. Stuart Cook is our chief law enforcement officer here in the county, and when it comes to things like the right of assembly and many other issues, law enforcement is always and quite often called in to respond to that. Fran Frymark is the director of the Pamunkey Regional Library, and I'm not sure that there are any more burning issues, burning First Amendment issues that are alive today that don't involve libraries in some way, and that's the reason Fran is on the panel. John Gordon, who's the chair of our Board of Supervisors, obviously is our elected official on this panel, and quite often both the governing body as well as elected officials individually are called upon to respond to First Amendment issues. And finally, Stuart Robertson, our school superintendent, And like Fran, he shares perhaps the burden this evening, because so many First Amendment issues in our day and time involve our school systems and things that happen in our schools, and so that's the reason for Stuart's presence here tonight. My good friend and colleague, Louise Seals, the managing editor of the Times-Dispatch, is our moderator, and I hope you will enjoy what should be a very stimulating discussion. Louise?
Jay, thank you very much. We are going to start out with one of those burning issues, and it's going to be cutting edge. A 12-year-old boy uses the computers in his community library to go searching the internet. He finds sexually explicit images, downloads them on a diskette, prints them out at a friend's house, takes them to school, and passes them around. The boy's parents are angry with the library. They say that because the library lets the students use the internet without any supervision, they're like the store owner who puts out adult magazines where children can see them. At the least, the boy's parents say, the library should put a filter on that blocks sexually explicit material, or it should require parents' permission before letting children use the internet without a filter. The library says our computers are available to anyone. If there's any supervision of minors to be done, it's up to the parents. Mrs. Frymark, what's your view on this?
Well, my view is that the parents are responsible for their children. In the Pamunkey Regional Library, the library board spent almost a whole year, and I will point to our library board chair who's sitting in the audience to confirm this. The library board spent almost a whole year talking about internet policy and procedure before we opened the internet for public use. When you go to a Pamunkey Regional Library to use the internet, parents must give their children permission to use the internet before they're allowed to use it. Once the parent has given the child permission to use it, the child is free to use whatever they find on the internet. However, our library has done a proactive thing. Rather than filtering the internet, we've provided some selected sites. Just as we select the books and the magazines and the newspapers and other resources that are in our library, we have selected a number of internet sites that we know when they were selected had accurate information, were reliable, etc. And we suggest that people look at those sites first. If you're seeking information on a certain topic, here's a site that we believe has accurate information, and we'd suggest that you go there. So that's a proactive step. Rather than blocking anything, we're suggesting that you look there, and we do require that parents sign for their children's use. So in that way, we wouldn't have exactly that same complaint, I think, in the library, although we might have a similar complaint. I said they could use it, but I didn't say they could go there. Well, then that's something between the parent and the child, and the library doesn't want to get in the middle of that one.
The library may very well end up in the middle of it, and that means that the governing body would probably end up in the middle of it. So, Mr. Reeves, what would you advise the library in this situation?
It's interesting to note that the Supreme Court has traditionally viewed the protection of children from improper materials as a compelling governmental interest. And that means that as it balances the various rights of the parties and First Amendment and access to internet, it tends to be deferential to the government when it is seeking to protect our children. But I would note that the Supreme Court did overturn the Communications Decency Act of 1996 in a case in 1997. And that was a federal law that required that internet sites not make information available to minors, to try to put it most simply. The Supreme Court applied strict scrutiny to that case because it noted the fact that when you go on the internet, to access indecent materials requires an informed action of the internet user, and it distinguished it from broadcast media, which is sort of pervasive. Anybody can turn on a TV, flip the channels, and accidentally come across materials. So I think that's a difficult case. I'm not sure exactly how the courts would respond to the use of filters for everyone in a public library. I think it would be fine in a school setting because that's available only for children. But in a library, as far as I know, that's an untested scenario.
I believe there has been one decision in Northern Virginia where filters for everyone were ordered out. So, but
That
well,
would be consistent with it.
let's explore this issue of children and the internet, and let's move this one into the schools. Thank you for that nice segue. But we're going to change this scenario a little bit. In this case, yes, students are using computers in school during school hours to do some internet research, but the school board also makes their computers available to people in the community and students after school. Everybody was able to use the computers with very few policies, if any. But the situation has just changed during school hours because one student was found to have accessed some unusual websites. One was about Buddhism. There were a number of others of mixed sort of weird things. But the one that got people most upset was about sort of a nature-based benevolent form of witchcraft. There were no sexually explicit materials involved in this case at all. But as a result of this student's finding this material on witchcraft and these other sites on the internet, now there is a policy at the school that students may not access controversial materials during school hours. What constitutes controversial materials, Dr. Robertson?
Whatever Sue Watson believes. One of our school board members is in the audience. I thought I would just introduce her. What constitutes controversial materials? We, as a practical matter, as school administrators and policymakers, school board members included, rely upon the leadership which is provided through community representation on school boards and through task forces and communities and task forces and committees and other forum to help determine what materials should go into libraries, what materials should be selected as textbooks, and that's all regulated and prescribed by school board policy. And we derive our direction from the courts, who have held that as long as we have established these procedures which represent the mores of the community, then we're in a position to define what is controversial, or for that matter, what is obscene, what is lewd, what is vulgar, and then take the appropriate action to exclude or include. So controversial as a definition is going to change from community to community, and it will be reflected in the decisions made by the policymakers.
Let's say that the student who accessed this website on witchcraft was an honors student who the previous summer had taken a course on various religions and philosophies. Mrs. Hopkins, how controversial do you think the material she accessed was in light of that?
I must tell you that I don't have a problem with the student doing any of what you've said so far in the second question. The first question I do. But I'd like to make an observation before I attempt to answer that. And this is just a practical, common sense observation, I believe. I think that technology and children have advanced a lot quicker on the computer than the adults have. And it makes this thing an unusual situation. My children know more about computers than I do. My students, when I taught, knew more about computers than I do, but it's the adults who make the decisions. That doesn't answer the question. I think it just points out how complicated it is. But being a government teacher and being a former liberal, flaming liberal. Yes, sir. There are things that die hard with me, and accessing material that is controversial is not a problem for me. Material that is obscene, lewd, vulgar, pornographic, I think has a whole different category, but controversial material is not something that I can speak against. And my honor students would be able to do that.
Okay. Mr. Reeves, you
I
had
just
a...
briefly make the point that, in my view, any policy that banned access to, quote, controversial materials is going to fail on its face. It's both vague and overbroad, and would be void for that reason. It has nothing in it that would guide the discretion of the school administrators who are supposed to enforce it, so they would be free to discriminate against materials that they just don't like.
What if we found out 2 boys had accessed a website that extolled violence as a way to settle conflict? And one of them is an honor student, but the other one has had a number of scrapes with the law. Colonel Cook, would you be concerned about that?
I don't think you can distinguish between the 2 students because one's an honor student and the other one has had problems with the law. I think the same principles as far as the Constitution applies to both.
Dr. Davis, how are they doing?
I think they're doing fine.
Okay, well, let's move into a different realm. Let's move into advertising, which is commercial speech. And let's say that you have a community baseball field and you sell advertising on the wall. And a local businessman wants to buy some ad space. This is, of course, not unusual. Service clubs buy it sometimes too. But this businessman wants to display verses from the Koran. The field manager says no, he can't put the advertisement up. The businessman says this is a violation of his free speech rights and his religion rights, and he's going to sue. Officials say that this will violate the separation of church and state. Mr. Gordon, what do you think your field manager should do?
I assume that the field is a county-owned.
Well, let's say it's community-owned, government-owned, yes.
Then I think the advertisement should not be allowed. I think that it would be, in fact, an endorsement of a particular religion, and therefore shouldn't be allowed.
Mr. Thompson, what do you think about that one?
I'm inclined to agree with Mr. Gordon. It becomes a endorsement of a specific religion along the way. No more than we could put up any biblical verse on a billboard either. So,
Okay, so it wouldn't change your mind if he wanted to display the 10 Commandments?
no, it would not change my mind at all.
Mrs.
Not
Bradley?
even if it was identified as a paid advertisement from Joe's Auto Shop?
Not even if that was the case, just as I would not support alcohol advertisement on a county-owned facility.
Okay, well, let's change this a little bit more. Let's say that the businessman doesn't want to advertise any religious sayings. Let's say that he's in the business of selling bathing suits. And he wants to advertise swimsuits. He wants to include some models with bikinis and one wearing a thong, photographed from the rear. What do we do now?
I assume it's the same facility?
It's the same facility.
This is not a school facility?
No, this is not a school facility. That would make it too easy.
Ticket sales are up there.
And the home team will win every game because the visitors are too distracted to play.
My personal opinion is I would not find that offensive, and therefore I would probably support it.
What about somebody in the community who might? Mrs. Hopkins? What do you think about that?
I would have supported the Koran on the billboard. It's not the county government suggesting that Islam or Christianity or anything else is what we ought to do. It was a businessman, as I understood it, who happened to have particular religious beliefs. So I would say that he can do that.
Sure, Dr. Davis.
There was a case several years ago involving the placement of a cross, petition to put a cross on the lawn of a city hall or a county courthouse, I do not recall which, where other kinds of symbols have periodically been displayed. In this case, the cross was intended to be placed on that lawn by a petition from members of the local chapter of the Ku Klux Klan. The Supreme Court held that so long as the policy of allowing private groups to place symbols for specific periods of time on the lawn existed, you could not discriminate on the basis of the content, and that this did not imply simply by being a sign that represented, say, a religion or a particular point of view. This did not represent an endorsement by the city or by the county of what was being presented. So I would, like Mrs. Hopkins, argue that the Quran ought to be put up there, since it is not intended to be anything other or seen as anything other than an advertisement and not an endorsement.
I think
Mr. Thompson?
It seems to me one of the frustrations that I've run into with the whole First Amendment issue is so often we deal with it from a reflection of the community itself. And there'd be some places where that would not be offensive. But even in church, we reflect the almost the political mores of a community. I believe that we need to look, as Christians, we need to look at things through the eyes of our faith. But it's broader than that. To look at it between how the community responds to it. Hanover County is more conservative than a lot of communities. The Quran probably would be an offensive thing, but Bible verses would not be in Hanover County.
I'd like to say,
Mr.
I
Harris?
think, and this doesn't reflect my profession at all, but just a personal point of view, it seems to me there should be a limit as to how far we allow community standards to limit what people can say in the free exercise of their religion, which is, after all, a matter of individual conscience. I never quite understood why someone living in Hanover County should have less right to put a Koran on the ball field fence than, say, someone living in Albany, New York. Why? Is there some kind of a sliding scale in the Constitution that I missed? I don't think so. I think the Constitution applies to all of us, and I think that that person in Hanover County should have every right to put up that sign as the person in Albany, New York would have, regardless of what the community thinks, whether there is a person of the Jewish faith in the community or not. I think that's irrelevant as far as the Constitution is concerned.
Mr. Gordon, you have a...
I think there is a sliding scale in terms of interpretation. And I think, what we're talking about is law, and lawyers and judges will have to make the final decision. But in terms of interpretation, I think it's a sliding scale. What is seen as acceptable and constitutional in New York may not be the same as what is seen in the state of Virginia.
Lawyers will take on that case, I'll bet.
Well, Mr. Thompson mentioned that even in church things are frequently viewed through not whether the community is Democratic or Republican, but where the community is on the political spectrum. So let's take our scenario of selling an ad on the county-owned ball field fence one step further. And what if the businessman this time wants to put up a message that says, Clinton sucks?
That's a bad taste, and nobody should be allowed to have a bad taste on it.
What if they change the word from sucks to something else? Just not jokingly, but seriously.
No.
To get to the heart of the matter, is the issue politics, or is the issue the phraseology of the word? Because I think
Or
that
is it
is
the right
important.
of the right of free expression? If you are selling advertising to businessmen and to service groups, and you are not, one of the things we didn't talk about was if you did do this, is there any kind of general preview of the content of the ads? These questions are never easy. These community issues are always very, very difficult. And 2 or 3 or 4 little words.
But nevertheless, there's certain words that you can't say, it seems to me, I'm not a lawyer, but within that form. There's certain things that you can't say. I don't know that sucks would fall under that category.
Yeah.
But you cannot use...
You can't scream fire in a crowded theater.
You could be charged, the last I know, for
That
curse and abuse. If I say certain things to anyone in this audience, the sheriff could slap his handcuffs on me, which I understand that he's brought with him just in case someone gets out of control. And I've got a lot of trouble because I've got witnesses here.
Yeah.
That's the point I'm getting to.
Mrs. Frymark, yes.
Since this is a county-owned facility, I'm certain that the county would have established policies and procedure for the sale of its ads. That John Gordon would have asked Sterling to do that, and he'd have done it. And those parameters would have been defined long before the county began selling the ads in the first place. And that might give us some guidance and protection to help us walk through this minefield. However, if it's not a county-owned facility, then the issues are still up in the air and completely different, I think.
The issue. Sterling, you look like you want to say something. Mr. Reeves.
So many issues here. Where to start? You know, when you're talking about verses from the Quran, and there you really have a classic conflict between 2 First Amendment rights, and that's the freedom of religion and freedom of speech, and the ability of government or the necessity that government not establish or promote any given religion. So you have a conflict there. When you get to the bikini ad, then you're clearly talking about commercial speech, which traditionally has enjoyed a much less level of protection by the courts than political speech or speech that involves legitimate public controversies.
Or expression of religion?
Yes, but of course, with religion, then you've got the countervailing argument, that the government can't promote any given religion or can't be seen to. When you get down to the Clinton sucks comment, I would disagree with Tom that the key word there is sucks, because there's actually a case on that I can't recall the name of the case, but it's from the Vietnam War time where a draft protester had the war sucks on a coat, and he appeared in a courtroom and he was arrested for
It was the other word.
for indecency.
It was the other word. It was the other word.
Oh, you're right. It wasn't sucks, it was another word. But in any
He still got off.
in any case, he got off. So the key wasn't that. I think that the point here is whether the government is acting as a regulator of speech or as proprietor of property. And I think as proprietor of property, it can establish reasonable time, place, and manner restrictions that would, as Ms. Frymark suggested, create parameters within which the advertisement could take place. And many places do this, like New York City has rules about what you can put on its buses and what types of ads and so on.
Yeah.
Can I just say one thing?
Yes.
It seems to me that often when these controversies come up, that almost unintentionally there's a line drawn and people start to get their backs up over this stuff. It seems to me a lot can be accomplished in most communities, and I think in this community especially because of its size and its roots and so forth. Why not approach this businessman and say, this may not be such a great idea. Before we start talking about lawsuits, and this might hurt your business. You might not be doing for yourself what you think that you'd like. Or it just seems to me that we sometimes, in an effort to avoid lawsuits, overlook the obvious, and we get into a policy of avoidance instead of one of practicality and principle and common sense and those kinds of things. I think, since I'm no longer in the school system, I can say something that I have felt for a long time, that in the school system we use that a lot, this policy of avoidance. No, you can't do that because somebody may bring a lawsuit. I think it is highly unlikely that in most of those situations where I was told or other teachers were told that, I don't think that's going to happen very often. And I think if we just talk about these things and we view what we believe to be important and so forth, we can get a lot more accomplished than we can with the threat of lawsuits and the fear of lawsuits, not the threat, the fear of lawsuits.
Mr. Harris.
Too, that there is a real First Amendment core to this, and I understand what Condi's saying, and that is really a very practical way to look at it, and could be done more often. But in any scenario, if you have only one person in the community who feels that way, I believe that person has got the right to do whatever the courts allow him to do, and he has the right of freedom of speech, as any of us do. It's not a majority-minority issue in the First Amendment issue, or at least it should not be. No majority has the right to decide, well, you should go along with this because nobody else in the whole community feels this way. The reason that we have a Bill of Rights is because our founding fathers were wise enough to realize that wasn't going to work, and that if you had a situation like that, the majority would always keep the minority down. And so they attempted to protect the minority, because the minority, frankly, are the people that need protecting in our society.
Well put. Let's move on. There are some of these issues where not talking to other people, where taking a hard and fast line will come back, as we will see in a few others. But right now, let's try a change of pace, and let's look at another area of First Amendment expression. Let's say that a local theater group plans to perform a play that is controversial because characters are often nude on stage and acts of violence are portrayed. All publicity has warned theater goers about the nudity and violence. But the group is disappointed by its ticket sales and decides to try to drum up some business. Actors in costume, or lack of costume as the case may be, go to the biggest mall and stage 3 or 4 of the controversial scenes. Should they be allowed to appear nude or nearly nude in public? Colonel Cook?
Well, we'd have to look at the obscenity statute. There's two different issues here. I guess you talk about the mall, whether it's private property or public property, whether it's going to be exposed to the public. And I'm assuming that, has the mall invited these people in?
That I think we could discuss it from either one. As you said, public property or private property certainly makes a difference.
Sure, it does, and there have been court decisions both ways as to private property and public property, and it invariably seems to invoke itself around malls, which are considered to be a shopping mall which is owned by a private corporation, and then where are people going to demonstrate, whether it's for obscene purposes or any other purpose. It may be a legitimate, some other legitimate purpose in their minds that they are picketing, whether it's because of inadequate pay or whatever. So getting away from the obscenity statute right now, but just looking at the right to picket, we'd have to determine, first of all, is it private property or is it public? Certainly, again, away from the obscenity part of it, if they do have a legitimate right to picket for whatever their cause is, as a property owner, I have a right also to determine whether you're going to interfere with the ingress and egress of my customers. And the courts have pretty much said, I think, in the latest decisions, that they have a right to preclude you from picketing immediately adjacent to their property. You can go out and picket on the public sidewalk, the public highway, or whatever. So that would be explained to the picketers, first of all, about the constitutional issues and the property rights. Now, the obscenity statute is a very difficult one for us to enforce, I can tell you, because, again, it goes back to the community norms and what is considered obscene and who makes those determinations. And so that would have to be viewed, and it's very complex, and people don't understand. I think the average citizen doesn't understand why law enforcement can't walk into the local bookstore or the local video store, is a good example, where there are X-rated films that are rentable. But who determines whether it's X-rated, first of all? And in order to determine whether it's X-rated, the community has to establish those norms, which means to us in Hanover, they would have to get a select group of citizens from throughout the county, put them on a panel, go down, rent a couple of these movies, display the movies to this group of citizens, and they would have to make the determination as to whether they thought that they were obscene, and they would establish the community norms. And then from there, you have to go to a circuit court judge who would then view it and make a determination as to whether we have probable cause to charge a man with distributing obscene material. So it's a very complicated process. And so whether they're nude, obscene, or whatever would have to be determined. Certainly if they're causing, if they are nude, I don't think it would be a real issue. But if they're in skimpy clothing, then that could be one of those borderline cases.
What if you decided to convene a community panel, as you talked about, and the case, then the judge makes a determination, and a legal case does result? Would you tell members of the community who among them helped make the determination that these actions were obscene?
Rephrase it?
Would you tell the entire community who among them was a part of the group that helped make the determination that this was obscene?
Would I tell the entire community?
Uh-huh.
At what point? I'm missing a point.
Let's say you create a panel.
Okay.
You ask people to come help you decide whether this is obscene.
Sure.
And then a case,
emanates
develops.
from that?
A case develops from this.
Okay, and an arrest is made?
And an arrest is made, and the judge agrees with you.
Then a court hearing is had, whether they're found guilty or not guilty.
Yeah.
And all of that is a matter for the press to publish or
Yeah,
not publish.
but are you going to give the press or the rest of, and thus the rest of the community,
The names of those
the
citizens.
names of the citizens who helped you make that determination, or are you going to keep it secret?
I've never known that to come up, but I don't know that that would not be a matter under the FOI that they couldn't get that. I think it's just like a grand jury, I guess.
The reason I ask is because there is a particular law enforcement official who has a community board to help make those decisions and refuses to tell anyone who's on it.
I'm not sure that you can do that. But if he's getting away with it, if he's getting away with it, all right.
At least he did for a while.
Our sheriff wouldn't do that.
Well, I mean, if it has to be.
No, I wasn't trying to put you on
No.
the spot.
No, and I don't-
That's why I was asking the.
I don't think that that's something that should be held in secret. I mean, if we're going to establish the norms of the community, then it should be a group, and a well-represented group of the community to establish those norms. But it is a very, and I'm sure Dr. Davis can explain this much, and Sterling much better than I, but it's a very complicated issue because, again, you're looking at First Amendment rights as to who's going to determine what I can view and can't view, who's going to determine what I can read and can't. And oftentimes, law enforcement is pitted right in the middle of this controversy as a frontline defender or offender of these constitutional issues.
Mm-hmm.
And ultimately, it will be a jury that decides.
And ultimately, they'll go to the Supreme Court. And they will determine that law enforcement fouled up or acted correctly. But they've got to do that within a matter of seconds.
Mr. Reeves?
I think it's important to distinguish between obscenity on the one hand and what is broadly classified as adult entertainment on the other hand, which may involve a lot of nudity and other things, but may not classify as obscenity. Obscenity is a very hard definition to meet. One Supreme Court justice, you can probably say who it is, Stewart, said that, I can't define it, but I know it when I see it. And one of the elements in obscenity is that it be without redeeming social value. And so this play, assuming that it has any artistic merit at all, may well not be obscene, even if there's lots of nudity and other stuff going on in it. So obscenity can be prohibited by law altogether, but adult entertainment or other forms of entertainment that may involve nudity and other things cannot be, but the government can subject it to reasonable time, place, and manner restrictions. And that's why we have laws against public nudity, which presumably would apply to these people who are out in the mall, and assuming that they're reasonable and based on a legitimate government purpose, such as preserving law and order and public morals, that should be withheld.
But we can still put the ad with the bikinis and the thong bathing suit photograph from behind on the at the ball field.
You can do that, but then the government also can regulate that.
Yeah.
So the question is whether the legislature wants to regulate it.
Mr. Gordon.
In preparation for this event, I read the Constitution for this for the second time. The first time I was required to do it in 10th grade government class. And I was surprised with how brief it was, not very detailed, and I think that was intentional. And I think that, again, it leaves a lot to interpretation. I think there's a lot of common sense in the Constitution as I interpret it. And nudity in a public mall, based on my common sense, is obscene, and therefore would not be supported.
I just want to ask Sterling whether he's going to advise our law enforcement officers to charge these people with causing a common nuisance or causing a traffic jam, or to arrest them for public nudity.
Well, before he answers that, let me change this just a little bit. What if the actors, instead of trying to sell tickets to a play, are trying to awaken people to the dangers of hate crimes? Let's turn this into a church dramatic group that has written a play about how a community becomes the breeding ground for violent crimes and hate crimes. Their play, again, shows nudity, but it is used to show how it degrades people, and acts of violence are portrayed in increasing intensity until a heinous crime results. The church group is presenting this play only on the streets so that it can reach the broadest audience possible. Does this change any of your views about the scenes from the play?
That's changed mine. First of all, the church group wouldn't do that.
Depends on the church.
I've known some church groups that would.
Yeah. So, yeah, it wouldn't change mine. And it goes back to what I have felt all along. Even with all the First Amendment issues we talk about, we still reflect where we live. And so the bikini girl, the thong girl, wherever she is, she may fly up in Yankee Stadium, but she might not fly out at the Diamond somewhere. And that's why the First Amendment issues are so, it's just such a struggle, because we are such a reflection of where we live.
But I think if it doesn't fly, then it's not going to sell tickets, and it's going to go out of business very quickly, which is not a First Amendment issue, I think.
Yeah.
I think that's a free market issue, an issue of capitalism, which is a whole other thing.
If these people are in the street, do you mean literally in the street?
Like on the sidewalk, or again, it could be, when I say on the street, as in, street musicians, street theater, going back to some of the 60s and 70s types of protests. You still see some things like this in some areas, street festivals. You'll see actors and groups.
Streaking at VCU?
Yeah. Public areas.
Right.
Public areas.
And they
Could
would
be
charge
parks,
public nudity.
playgrounds. So the street, as opposed to being in an auditorium.
It doesn't. It really doesn't change because who's putting it on, or the facts. You've changed them a little bit, but the circumstances that we'll have to deal with are basically the same. And I think that Ms. Hopkins is correct. If we know in advance that something like this is going to take place, then we, from a law enforcement standpoint, would meet with the people that are going to put on such an activity, whether it's the church or just a bunch of individuals that have decided to do that, and explain to them what the statutes are that they could possibly be violating, what the consequences would be if they do that, and encourage them not to go forward with their intended actions, whether it be a play or whatever.
And you would tell that to a church group also?
Absolutely. Absolutely. It would make no difference whatsoever. And certainly, again, having advance notice of that, we would be conferring with the county attorney as well as the Commonwealth's attorney to make sure that the law enforcement officers that have to deal with on the street immediately would have the best advice that we can get at the time, and then act accordingly. But hopefully we could resolve it before they did that. But I can tell you, as you know, better than I, probably equally as well as I, that there are certain groups that are going to do it just to test you. They're going to do it just to make a stand or to make a saying or a cause.
Or to get us in the TV cameras there.
Exactly. And to get that point across. So we would then do what we have to do and on the best advice of counsel. And then the courts will determine whether we violated the First Amendment rights or whether we did.
And advice of counsel would be?
Well, one important distinction here is that it's in a public street, because streets parks and sidewalks are the traditional public fora, the traditional place where speech occurs and where it is most protected. Now, this is not exactly pure speech. This is conduct that conveys a message, is intended to convey a message. So it is speech, but it's not pure speech. I think my read is that the result would be the same, that the public nudity laws would still apply, even though it's a public forum, and even though it is, the conduct is intended to convey a message, because the government has the authority and the responsibility to harmonize different public uses, even of public fora. And one of the ways it does that is by imposing time, place, and manner restrictions, and I think those would be upheld in this case.
And there has to be, I think, also the possibility of alternative ways of putting the message out.
That's correct.
And in this case, there obviously would be, other than to do a street demonstration that would involve nudity, no matter who is doing it and for what purpose. There are alternative ways of achieving the goal that they want to achieve.
Colonel Cook?
I think that the Richmond Bureau of Police, the city of Richmond is dealing with this right now on certain concerts that are coming to the Coliseum. And I know in the past they've had a group that would come in and had a history of beheading babies and throwing the body out into the audience. And they were met with beforehand and advised what would happen if that took place within the city-owned facility. And fortunately it didn't happen. But they have a group right now they're dealing with, and if they come in and do perform the type of acts that they say they are, then someone will be arrested.
Well, let's switch, because I mentioned the press just in passing when there's a controversy that, usually we show up, the TV cameras show up. So let's talk about the press now. A local government, let's say your government, settles a sexual harassment complaint with a longtime employee, but you refuse to talk to the newspaper about it. Mr. Harris gets some documents related to the case sent anonymously through the mail and starts asking questions. You go to court and you get a temporary restraining order to prevent the newspaper from publishing because you argue that the records may contain privileged attorney-client communications. The newspaper argues that preventing it from publishing a story based on the records it has is prior restraint, which has almost always been held to be unconstitutional. The newspaper says any chance of violating attorney-client privilege is far outweighed by its right to freedom of the press. Well, now, as taxpayers and newspaper readers in the community, what do you all think is the right thing here? Should a constitutional club like prior restraint be used? What are the employee's rights? Does the employee have recourse if the story is published?
I think settlements are made all the time that both parties agree will be held in confidence. If I'm to believe what I read in the paper, that is a common practice, and I think that needs to be honored. The other problem I have with your scenario is that the documents that were received came surreptitiously somehow, were anonymously sent. Didn't you say that they somehow appeared?
Anonymously.
Well, that's unfortunate and unseemly, but it's probably not against the law to do that. But I don't think that falls under freedom of information. It's not like they got documents that they were justified in acquiring, but rather they landed on their doorstep at night. And so I think that makes the case, for me, pretty easy. You don't publish it.
Well, it's not a freedom of information. It's not a freedom of information issue. No, you're right. It is not a freedom of information issue, and there is a separate law that governs what is available and what is not. Well, actually, there are a number of laws that do. But what about going to court to prevent the newspaper from publishing? Prior restraint is a pretty serious matter. Mr. Harris, you're sitting there being very quiet.
Well, yeah, because I'm very biased in this kind of situation, so I may not be the right person to ask. Yes.
You go ahead, and then I'm sure the others will.
I'm sure that my friend Mr. Reeves will disagree with me,
but
I don't know that attorney-client privilege shows up in the Constitution, so I'm going to claim a higher priority for freedom to print that information. I think we have the right to print it. We obviously could choose not to print it, but choosing not to print it would be an editorial decision made by the staff. It would not be made by the community. It would not be made by the county government. It would not be made by the parties involved. The newspaper would print it if we felt that this was something that the community should know about. There may be circumstances in which we wouldn't print it because we felt like there was something unusual about it, that we had some doubts about the information being accurate. If it was literally given to us and we had no idea where this information had come from, I don't think we would feel very comfortable going ahead with it unless we could verify it somewhere. Then we'd really be taking a legal risk, and I think there's a certain element there's an ethical issue to this as well as an ethical element to it. In that if we print something that we don't even know that's true that could hurt someone, I think we would consider that. But that would be an internal consideration. And I don't think it would be very, I don't think anyone else would have anything to do with it, frankly. We would just have to make that. New staffs make judgments all the time, and what we think we feel solid about and what we don't feel very solid about. And we're not in the business of printing rumors. We're not in the business of printing things that we don't feel like we can verify, that we don't feel like are true, frankly, because we just don't see that as being our mission. But if we think it is true and we think it is news and that the community should know about it, then I suspect we would print it. And how we receive the information is basically something we would have to chew over.
I actually agree with him. I'm just saying that I think the paper shouldn't publish it. I didn't mean to say they couldn't publish it under any kind of, I just don't think they should. Given the facts that you presented them, I don't think you should. And I agree, it's an editorial decision among the staff.
Mr. Gordon?
I don't think I can't recall whether he said this was a teacher or a county employee, but.
Just said a longtime employee.
County employee.
County employee.
Your turn's coming, Dr. Robertson.
I was dozing.
I don't think it would be the county's responsibility to take action to prevent the paper from reporting a story that the county did not initiate. I think that would be the responsibility of the individual involved to challenge the paper's ability to print that story. So that would be my position. Without the benefit of counsel, that would be my position.
Well, actually, I find myself in the unusual position of agreeing with Tom. May need to reconsider here, but it is clearly, it's classic prior restraint.
Yes.
And by prior restraint, what that means is when the expression is blocked from ever happening as opposed to being punished for having happened. So it's prior restraint because what the government in this case, if it were to go to court, would do would be to seek this information from ever being disseminated. And the government has a very heavy burden in cases like this to demonstrate an absolutely compelling governmental interest to keep the information from going out. You may recall back in the late 60s, early 70s, the famous Pentagon Papers case, where the government there was not able to restrain the Pentagon Papers from being published, even though it alleged that there were national security issues involved there. So as far as the attorney-client privilege is concerned, the fact is that's already been breached anyway because he already has the papers. So once somebody other than the attorney or the client has the information, the privilege has been breached.
Even if there is a law passed by a government which forbids the publication, say, for example, of the name of a victim of rape, a newspaper still can publish that name with impunity.
Mm-hmm. There are I guess in Virginia, for example, officers of the court and law enforcement officers are not supposed to publicize the names of juveniles charged with crimes, but the law says nothing about a newspaper or being able to print it or a television station being able to broadcast it if it learns the name. So there are several instances like that in the law.
learns the name through a public document of some sort typically, or from a public official.
So there are a number of ways. Well, let's look at a Bible club in a school. Your school board has been sued because there is a Bible club that has not been treated the way several other clubs in the school have been treated. There is a roster of student organizations. The Bible club has not been allowed to be placed on that. Most of the clubs can use the school's name in its publications or when advertising its activities. The Bible club has not been allowed to. And most of the school clubs can have their picture in the yearbook free. The Bible club had to pay $100 to have its picture placed in the yearbook in the back, away from the other clubs. Do you think the school board is violating the rights of the students in the Bible club, or is it trying to keep church and state separated in the schools? What do you want your school board to do? Do you want it to settle the lawsuit, fight the lawsuit? What do you think is the right thing to do?
First, I want to say I don't think that the thong ad is going to be in the student newspaper. If the facts are all the way that you presented, I think that the Equal Access Act in the 80s took care of nearly every one of those questions. And my recommendation would be to the board either to do away with all clubs in the school or permit access to the Bible club as part of the extracurricular programming of the school. The Equal Access Act says that's what you have to do. And in the facts that you presented right there, it's clear that the Bible club is being discriminated against under the Equal Access Act because there are clubs in existence and this club does not have access. The only other option is to let them in. There are two options: to let them in or to move all clubs out of the school. My recommendation would be in our community, the Bible club actually exists, so that's not the toughest question I could get this evening.
It may not be. Mr. Thompson, what do you think?
You know, I agree with Dr. Robertson on that because it seems to me there's a place for it, and it's not imposing its beliefs on anybody. You choose to be a part of a Bible club, so why not have a place for it as just any other club in school?
Although there was an actual case, I think about a year ago, where a gay lesbian club in a school wanted to meet, and the administration took the opposite view, which was we will eliminate all clubs rather than have that one club be present. I just offer that because I remember reading it. I don't know how that plays, but I think that Bible clubs aren't as controversial as they used to be. Now we have other controversies that come up, and that's the tougher question, I think.
If there were clubs who wish to be organized, whose primary motivation or primary reason for existence was to promote hatred and therefore to engender disruption within any environment, especially schools, then I believe we have a set of facts then that would permit us to say, yeah, the Equal Access Act deals with this set of circumstances, but in the case of someone presenting themselves to us as being outwardly hateful and outwardly disruptive, I think that's worth taking the risk of putting energy into rooting out that particular issue as opposed to dealing with the Equal Access Act implications.
Anyone else have a comment on that one? Okay, well let's move on then to a slightly different scenario that involves an individual that some of you might find a little hateful, but in this case, it's not a student, it's an adult. Let's talk about the right to petition government for a redress of grievances. A high school baseball player collects the signatures of 20 of his teammates on a petition asking the school board to find a coach who is more suited to lead his team. What are the reasons the students do this? They say that the coach uses foul and abusive language to try to intimidate them, and that he embarrasses them and the school in front of opponents by screaming, cursing, and throwing things. The 20 teammates quit rather than play for him again. Their parents try to discuss this with the school administration and with the school board and get nowhere. The school district then suspends the student who circulated the petition for 7 days. Here's the reason. He was, quote, circulating inappropriate printed material detrimental and defamatory to the character of a faculty member, end quote. My question, first to Dr. Robertson, is, do all of students' First Amendment rights stop at the schoolhouse door? The Supreme Court has said that freedom of the press does. Should they? What kind of a message is this sending to our students about citizenship and standing up for what you think is right in leadership?
I think you do have to begin by questioning what the school officials were thinking by presuming that a petition couldn't be disseminated or signatures couldn't be collected. That matter is one which does create immediate concern for me. I have to know more than what you've stated to lead me to believe that petitions should be ever stifled. Now, I don't want to encourage them, but at the same time, I think that it's important for us not to have a condition in which students cannot feel as though they can collectively express themselves. As Sterling said earlier, there are a dozen issues wrapped up in that particular scenario, and the matter of what it takes to call the school board's attention to an employee who is demonstrating improper behavior is a question that I hear from there too. And I not only would ask what were the school officials thinking about the petition, but I'd also ask where was the principal, where was the human resources office, where was the superintendent in the whole series of decisions. Why was this at a point such that the parents felt that a petition needed to be encouraged and then presented to the school board? Presumably you would have, as Condi has said, more cooler heads prevailing and folks who would be willing to sit down and try to process some of these issues before it took on the public flair that this did.
Anyone else want to weigh in on that? Mr. Reeves.
I will add only that, of course, cases like this are going to depend entirely upon the facts. If the circulation, if the petition that the student was circulating did in fact contain defamatory material, if the process by which he did it was disruptive of the educational mission of the schools, then the school division is within its rights to discipline that student, notwithstanding the fact that he has a right to circulate a petition. So there's a balancing of respective interests that goes on there.
Let's say, for the sake of exploring the issues, that the student did everything the way it should have been done on wording the petition, on circulating it. But let's say that the main reason the students wanted this coach replaced was just because he had a losing record. Does that change your views any?
In terms of our response to?
In terms of response to the suspension and...
They've exercised their right to petition, presuming that they were not disruptive in doing so and that they were not defamatory in what they were doing. I still think that it would be more desirable for some other steps to have been put in the process, i.e. conferencing with the principals, the human resource officer, the superintendent, everyone along the chain of command. But my response to their right to petition wouldn't be any different.
Okay. Well, let's say that this controversy over the baseball coach has really stirred up the community, and we'll get it out of the school arena now. So, Mr. Gordon, we're coming your way. Now, let's say there are about 200 citizens who are coming to demonstrate on the courthouse lawn, and they want the student reinstated, they want the suspension lifted, and they want the coach out. And they also want the school board to listen to people who want to raise issues with them. Let's say that one of your colleagues is angry and tells Colonel Cook to get those people off the courthouse lawn. Do you have the right to tell him to disperse the crowd? Does the county have the right to order the crowd dispersed? Let me rephrase that. Does the county have the right to order the crowd dispersed?
Again, without the benefit of counsel,
You're doing very well on your own.
it would be, in my judgment, that the crowd would have a right to gather as long as they were not being disruptive and unruly. And therefore, I would not request that the crowd be dispersed by the Sheriff's Department. In terms of reinstating the student, of course, my board would not have the power to do that, but I would strongly encourage the school board to, in fact, do that, because I think the school board erred. I think the student did, in fact, have a right to petition. In terms of firing the coach, again, that's entirely up to the school board, and I'm sure they would come to the right conclusion to do just that.
Colonel Cook, let's say that folks are blocking traffic. The demonstrators have spilled out into the streets and they're disrupting traffic. What happens now?
We would meet with the leaders of that organization or the group that's marching and picketing and explain the parameters to them and advise them if they block traffic or ingress or egress, that they would have to be arrested. But we would encourage them not to do that so that they could peacefully demonstrate and carry on their grievance. But if they did block traffic, then they could and would be arrested for that.
Which might be what they want.
Well, it may be, but we would talk to them first and encourage them not to. That would be the last thing.
That's always a
You don't hear much about
possibility.
civil disobedience anymore, but that was a very common practice back in the
Sure.
60s, so that's not a new idea.
Oh, thank you for that segue. You all are just doing a wonderful job with it. You didn't really need me, Jay. All right, let's say that as part of the protest, because some people feel very strongly that the students' First Amendment rights were violated, a U.S. flag is burned during the protest at the courthouse. Does this change anybody's view? And if it does, or why does it change it?
That's a tough one.
That's a hot button.
Yes, it is.
Very hot button First Amendment issue.
Again, I'm not sure that my position or my opinion would have legal basis, but burning of the American flag on a public place, in my opinion, is not supported by the Constitution. Burning of the American flag in the privacy of one's own home, I think they have the right to do that. But in that particular scenario, I would think that is a violation, that's disruptiveness, and therefore they should be arrested.
Well, Mrs. Hopkins, go ahead. Go ahead.
No. It is a hot button. It's a hot button for me the other way. I revere the flag, and I especially revere the Constitution. I think I'd be more upset in the symbolic act of burning the Constitution than I would the flag, but that's really irrelevant how I would feel which is worse. The whole point of the First Amendment is to protect obnoxious, unpleasant, controversial, disgusting sometimes behavior, and though that may fit all of the reasons that you feel the way you do, it must be, well, I just feel so strongly about it, and I think that if there's any case law, it would be against your view. I mean, there have been cases, Texas, I remember, I don't know the name of the case, but I know the first flag burning case took place in Texas and another one subsequently. I know that there is now a new movement to add a constitutional amendment which will bring out the old protests in me from the 60s if that should happen, because it is absolutely, it's one of the easiest questions you've posed. It's absolutely wrong to say that a person cannot burn an American flag because it offends your sense of patriotism. That person may be just as patriotic who is burning the flag as the person who feels offended by it. And this really conjures up 60s kinds of sentiments in me. I just,
Dr. Davis.
The Supreme Court has answered this question emphatically, that the burning of an American flag as a protest, in this case a political protest, by a narrow margin of 5-4 in that Texas case, said this is symbolic speech. This is sending a message not by words but by a symbol, and the symbol is the burning of a flag. I wonder, given your example, whether burning an American flag in the context of the hiring or firing of a baseball coach is an appropriate way to send a message.
It does seem overreaction, yes, yes.
Might be a good reason to fire the coach.
He obviously stirs strong sentiments.
And it does depend on whose flag is being burned. If they bring their own flag and burn it, that's legal. If they come in and burn a flag that belongs to the government, then it's destruction of government property, which notwithstanding freedom of information issues would be illegal. But I would agree with Ms. Hopkins about the proposed constitutional amendment that would make it legal to outlaw burning of flags. I think that frankly is a greater desecration of the American flag than those who burn it, because it abrogates the very freedoms that the flag symbolizes. And I think I would join her on the picket line.
I can see right down the middle of the street, you know, two groups on opposing sides here. With equal fervor. With equal fervor. So. Well, let's move on to another type of speech. Let's look at a censorship issue and a right to petition. A 12-year-old student goes to the school board and asks to have a book returned to the shelves. The book is about an overweight fifth grader who is unmercifully teased by her classmates. Later, one of those who has been making her life miserable becomes the object of some teasing too and learns how hurtful it is. The book was banned because it uses the word damn twice and because it uses the word bitch to refer to a teacher. The school board reconsiders, and one of the reasons it reconsiders, you need to know, is that 3 members of the majority who voted to ban the book were defeated in an intervening election. So the board reconsiders and votes to return the book to the shelves. Do you think the board was right in removing the book or in returning it? What do you think would justify removing the book? Mrs. Frymark?
Well, I'm going to turn this over to the schools since it's the school library. They have to decide for their students. If the book were in a public library, I would say that if the public library board chose to remove it, I would say that they were wrong and that they were right to put it back. If the school board has to make that decision based on their educational objectives and what's going on in their school. I would say that if it was banned in the school library, the students and the parents would undoubtedly have come to the public library to check it out.
Dr. Robertson?
School boards do have wide latitude on matters like this, but if the facts as you present them are the case, if John Gordon, Sue Watson, and another member of the board, and another one forming a majority, were the driving force behind taking the book off or putting the book on, and they were the driving force, that's wrong, as the courts have indicated. However, the courts have indicated that process is everything as it relates to the selection of instructional materials and the placement of materials in school libraries. And I'll go back to my first question. If there is a constituted committee, and our school board does have policies governing this, including the appeal for a review of instructional materials. If there's a constituted committee which is established by the school board policy, which is then called into action around this particular question, and that committee then makes the determination that this is a good book or a bad book, and that committee's recommendation is forwarded to the school administration to act on, the courts have ruled in that case we've taken care of our duty. And the committee, though, is one that can't be comprised only of school folks. It has to be comprised of community folks as well, and those folks are selected by the school board to sit on that committee. But if the school board acted alone, they were wrong doing so.
Well, let's look at another topic about books in school libraries. Let's say that the school board decides to place in the junior and senior high school libraries books on creationism. The school board says that these are scientific textbooks that should be available to the students who want them. A science educator who helped the district evaluate the textbooks says that many of them are a joke or they're bad science. Some of them, she says, are mostly religious. Now, the U.S. Supreme Court has said that schools cannot teach creationism or that God created the universe. The National Academy of Sciences has said that in order for students to understand biology, they have to know about the theory of evolution. Mr. Thompson, as a member of the community and as a taxpayer, what do you want your school district to do? This school district.
This school district.
This school district in this scenario. What do you think is the right thing to do in this situation?
It seems to me that the right thing to do is to open up all theories of creation. Now, and the fact that God created the heavens and the earth as a part of the is a theory of creation, and to let that be one of the theories taught.
Mrs. Hopkins, how do you feel about that as a county taxpayer?
I really like Robert Thompson, and he knows that. But I disagree with this. I think you said at the end of that scenario that that creationism was being said by some to be bad science.
The science teacher who helped the district evaluate these particular books said that several of them were a joke or were bad science.
Right. Well, I think that creationism is not science, and I think that because science is the subject being taught, then you have to teach scientific theory. It is certainly a theory. Creationism is certainly a theory, but it is not a science. And so you cannot, in my opinion, bring it into the science room and say that because this is a scientific theory and because this is a theory on how the world came about, that it therefore must be science. It's not. It's not science. And I just want to do one quick personal comment. When I taught at Stonewall Jackson, this is back in the late 70s, I had a parent call me because the parent's child had asked me in class, do you believe in evolution or creationism? This was part of just a class discussion. And I said, I don't think that they exclude one another. And they said, well, you're just dodging the issue. I said, no. You can be very religious and believe that God created the world and did it through evolution. And that is, to me, the closest that I can come to justifying a discussion of creationism, and that is that it is a theory based in religion that I believe deeply in, but it is evolution that is the science. And discussions can take place in other arenas, but and in the classroom it can take place, but it can't be taught, not creationism.
But if we're just talking about putting books in the library, in the school libraries.
And what would be the reason for not doing that?
Well, because I think because the thrust behind it is that it somehow counteracts a scientific theory. And I don't think that it does. To me, they are not in the same, I don't know how to say this well. I don't think you can argue against evolution. Maybe that's where I have a problem. To me, the driving force was God, but that doesn't mean that you've got to choose between the two. And so I have trouble thinking that people who push creationism are trying to reject evolution, and I have a problem with that because it is scientific fact. And to say that if you believe this, then you have to exclude what is and has been proven scientifically, I think that's wrong. It's hurtful to our children's education, I believe.
Mr. Harris and then Dr. Davis.
I just want to say, I think the wrong way to rebut any idea is to censor books. It's not like creationism is being taught as a science in the classroom. The books are being made available. The students can either check them out or not check them out. It seems to me that if you think something is wrong and is bad and it has no grounding in fact, then the way to rebut it is to hold it up to the light of reason. You can't hold something up to the light of reason if you've silenced that other voice. If you said you have no voice, you're not allowed to express this viewpoint. And frankly, I think it's a little bit patronizing to students that we expect them to go out into the world and be good citizens and to think for themselves when we send the opposite message in school, which is, I don't think you can handle this. I don't think you should be exposed to this. I think we're sending a mixed message, and that's not the kind of message I'd like to send. I'd rather that students read about creationism and decide for themselves whether or not they think that it's true and discuss it with their teachers, discuss it with scientists, discuss it with their parents, discuss it amongst each other, because that's how you really learn something, not by something being taken away from you and being put on a restricted list and saying, well, you can't read about that. I hope we don't go down that road.
Dr. Davis.
Second what you say, Mr. Harris. The issue that you posed is an issue really of books being added to the library, providing that the library procedures are followed with regard to the addition of books to the library that you've described already. I have no problem with the addition of such books to the library. The Supreme Court of the United States has made an issue of removal of books from the library once they are placed there. And there is a First Amendment problem with regard to the removal of books based on content. The issue of evolution and creationism as generally has been posed is normally posed in the context of a course, and the Supreme Court has basically outlawed the notion of teaching creationism as a course, or even tying it to the teaching of evolution in order to assure the students hear both sides, so to speak.
I'll add to the courts have ruled that the teaching of creationism is the establishment of religion.
Yes.
And therefore, Gandhi's frustration is well founded, because a teacher then has to determine how far can I go? How far will I go with this particular discussion in my community before the community then begins reacting? And that's a tightrope for teachers to walk. I would submit that instructionally you can talk about one-celled organisms and how one-celled organisms give way to other organisms by virtue of looking at natural history. I mean, there is evidence out there to help us conduct those lessons within classes. However, the fervor by which we get behind that and then start promoting that as not just my belief, but the belief that you should have too, then starts driving wedges within certain communities. And while the courts have said that you do not have to balance evolutionary teachings with creationism teachings, I think it is wise in our school libraries to have the Holy Bible on the stacks as a reference tool, and to have other teachings which can help demonstrate that we're somewhat eclectic in our communities. Therefore, providing the opportunities for students to make their own decisions through their own research and reference work.
Let me just say that I misunderstood. I absolutely believe in allowing books into the library. I think jumping ahead and thinking it was going to end up in the classroom. And so I was representing how I felt about it in the classroom, but I absolutely agree that the books, any book, I can't think of a book that I don't think should be in a library, so I retract that.
If I can ask a question, Dr. Robertson, how do you deal with it when it comes into the classroom? We're a pretty strong Bible Belt community, and lots of churches will teach creationism. How does a teacher supposed to deal with it when a child is sitting there and say, well, golly, my Sunday school teacher didn't tell it this way, or my pastor didn't tell it this way?
Honestly, it's not an issue I've dealt with locally.
I'm not going to send my boys to do it either.
Right.
So
thank you. But if the issue came up of teachers instructing creationism within the context of their lesson plan, then I think the courts have told us that that's not to be taking place. So in that case, we would have to examine that situation and to determine whether that is indeed the set of facts and then deal with it appropriately. the teacher, though, who is involved in heavy, in-depth discussion of evolutionary theory, I think needs to make sure that those lessons are closely tied to the approved text of the school system and according to the documents which have been handed to him or her to guide him or her through that discussion, because if they don't stick close to that text, then they may unwisely veer away from the prescribed text.
So there are no easy answers on most of these, and as you can tell from the discussion of processes, approved texts, and other things, life has become infinitely complicated in lesson plans, choices of textbooks, advertising, regulation of public displays, and many, many other ways that affect us all, in some cases daily, in some cases less often. If every community could have a reasoned discussion as you have had today, we wouldn't have nearly as many court cases to look back on and gain guidance from.
Please join me in thanking Louise and the 9 folks for Cleveland. Another thanks to the Friends of the Library, and to repeat Lee's commendation of the work that the Friends do for our beautiful library here, and I think anything that we in the community can do to support what they do in our library system is certainly well received, and certainly make this community a lot stronger. I was thinking as we were going through the First Amendment, 43 words. 2 years ago in February, Pat and I were in Beijing the night that Deng Xiaoping died. And the hotel we were in, we'd come from San Francisco where in the morning USA Today was pushed under the door at the hotel. And we were in the hotel we were in Beijing, we got the China Morning Star, which is the state newspaper. And it was really fascinating for me to read how they went about writing about Deng's death. And literally no issue discussion whatsoever, a lot of hyperbole about his life and about the government being able to continue and so forth. And for a journalist, and we were there for like 4 more days or 5 more days, for a journalist, it was such a breath of fresh air to be able to land in Hong Kong, which this was before the turnover, and be able to pick up the copy of 2 English-speaking newspapers that were printed in Hong Kong and see how the world, and indeed how that part of the world was reacting to Deng's death. And I think that it's times like that in my life when those 43 words that James Madison had so much to do with really come home to me and really mean a lot to me. Thank you all very much for being here, and thanks again to the Friends of the Library.